All right, well, thank you very much, everyone, for attending. My name is Joe Bach, and I'm the president of the Rutgers Federalist Society. With me is Craig Long, 1L representative for the Federalist Society. Today, our debate is on the role of a judge, how judges should use legislative history in interpreting statutes and amendments. Our guest today is Rutgers-Camden School of Law professor Earl Maltz. Now, Professor Maltz is the author of over 50 articles on constitutional law and statutory interpretation. Professor Maltz earned his BA from Northwestern University and his JD with honors from Harvard. Professor Maltz teaches constitutional law and employment discrimination at Rutgers-Camden.
Joining us from our own Rutgers-Newark campus is Professor González. Professor González earned his BA in Civil Science from the University of Michigan with high honors, and JD from Yale Law School, where he was senior editor of the Yale Law Journal. After graduation from law school, he earned an MA in political science from Stanford University. He joined the Rutgers faculty in 1997, became a full professor in 2005. Professor González teaches constitutional law and currently researches into statutory interpretation.
Now, each participant will have 20 minutes. After that, each participant will have a 7-minute rebuttal. Finally, we will have a 30-minute question and answer period, moderated by Jack Long. Thank you very much. Thank you. Thank you all for coming. Wow. My approach to thinking about what judges should do in statutory interpretation is a little bit idiosyncratic. I begin with the idea that judges should adopt an approach that will help legislators do their job. Now, that's a little bit cryptic, I understand that, but let's start first with the idea of what the legislature does as a group. What they do, what the legislature as an entity does, is that it produces authoritative texts, that is, texts which are designed to resolve legal disputes and to a certain extent displace other texts which might be authoritative. That's what the legislature as a group does. The problem that an individual legislator faces is different. The question is, he faces the question, should I vote for a particular text? In order to decide whether he should vote for a particular text, the legislator has to try and figure out what impact the text is likely to have on the law. Now, in order to figure out what impact the text is, the problem is he's not going to decide what impact the text is going to have on the law. It's often the judge who may or may not have the same view on things that's going to decide that. So the problem is that in order to really do his job, there has to be, for the legislator to do his job, there has to be some sort of authoritative interpretation of the legislation, some source that will provide an authoritative interpretation of the legislative language before he votes. And the source has to be authoritative, considered authoritative by both the legislator himself and the judge. Now, I should say preliminarily that immediately knocks out a couple of things. First, it knocks out something that had a brief vogue, probably 10 years. I've been doing this a lot longer than you have. So I'm thinking of the dynamic statutory interpretation, which had a very brief vogue about, 15 years ago? 10 or 15 years ago? God, I don't know. And basically it's the same as the theory of constitutional interpretation, which is prevalent among some people, which basically says you make it up as you go along. Right? You look at the text and you say, what would be a good interpretation of the text given the current condition? Well, obviously, since the legislator can't know what the current conditions are going to be 10 or 15 years ago, let alone what Anthony Kennedy is going to think about is a good interpretation or a good policy result 10 or 15 years from now. That's not going to work. Interestingly enough, however, it also tends to, not my view of the approach, tends to knock out one of the more traditional approaches. The idea that the legislation should be interpreted according to the subjective intention of the legislator, intentionalism, pure intentionalism. Because I might have a subjective interpretation, he might have a subjective interpretation, she might have a subjective interpretation, and besides, even from that perspective, it's hard for the judge is going to, what looks like the subjective interpretation for most legislators from the individual legislator voting might be different from what looks like from a judge 10 years from now. So where are we? How can we find this ex ante, which is a fancy way of saying before the fact, authoritative text, authoritative interpretive text? Well, the most logical candidates there are two. Committee reports are number one, and statements of sponsors or floor managers are number two. I think committee reports are the best example because that's also consistent with what I take to be the actual legislative process. Let's say we're in Washington, we're talking about federal judges, so I guess we're talking about federal legislation. And based on my limited understanding of what the way the legislative process works, that very often while your sort of rank and file person on the floor is out drinking and raising money, his aides there are committees where the members and their aides are drafting these committee reports, and then the congressman or his aide is trying to figure out whether to how to vote on something, and he reads the committee report. Okay? So that is the committee report, and that's how he figures things out. So if the committee report is authoritative, if the judge considers it authoritative, then the rank and file member of the legislature can have a way of making a better estimate of what impact that the legislation is likely to have when it's passed. Now, also, interestingly enough, there is a parallel for this, although people normally don't think about it as a parallel, and that is the judicial opinion. If you think about the way the judicial process works, or what judges are supposed to do, what are judges supposed to do in a multi-member court, right? I'm thinking about a multi-member court now, you tell it. They're supposed to do three things. There are three parts of the opinion, right? The first part of the opinion is how we resolve the case. The second part of the opinion, or the second part of the judicial process, is very much like what you would think of the formal legislative process itself. That is, the judges describe a rule of law which tells them how to decide the case. That is, the rule of law is a text which is similar to the rules of law which are text in legislation, right? The difference is that there is this, just as the parallel of the committee, if you will, is the subset of the judges, the one or two judges, who is assigned the duty, right, whatever, of writing the opinion, which will describe the way that the rule of law should be applied in later cases, right? And by looking at those judicial opinions, a judge can decide whether he should vote with the majority. Just as by looking at a committee report, right, the legislator decides whether he should support a particular bill. Now we don't even think about that as we don't even think about that parallel. We say, oh, judicial opinion, that's sort of a natural part of judging. Not really. You don't need the judicial opinion to decide a case, right? And in theory, you could have rules of law which are just naked rules of law, just as you have the naked rules of law that are in legislation. Now, there are some differences. One difference is that, first, the most important difference is that everybody accepts judicial opinions in general as authoritative interpretations. There are, I could give 100 examples, or at least 2 or 3, or maybe 1 if I went to the library, of cases where there's a text which is the rule of law, and lower court judges say, oh yeah, the text says this rule of law says this, but the opinion says that, right? And so therefore, even though on the face the rule of law may mean X, it may seem to mean X, because of the judicial opinion, we should say it means Y. I'm sure you've seen those, right? So, but everyone just accepts that as authoritative. We don't even think about it. The second thing is, of course, that there are differences again in the process. A second difference in the process is that because of the size of the multi-member bodies we're talking about, usually at most 9 judges as opposed to maybe 400 legislators, there can be negotiations about what's in a judicial opinion. So Judge X can go to Judge Y and say, I will support this if you change your authoritative interpretation in this way, in the judicial opinion, then I can support it. Obviously, for reasons which are having to do with the mechanics of it, that's not going to work in the case of legislators, right? Because basically, you can't have, every time you change one sentence in a committee report to get one vote, you're liable to lose another vote. So you're going to have these committee reports and they're just up and down. Lastly, in purely formal terms, judges do vote for for judicial opinions, whereas in purely formal terms, legislators do not vote on committee reports. But if my account of the legislative process is correct, right, if my account, and there was widespread acceptance of the idea that committee reports ought to be considered authoritative in subsequent interpretation, then in effect, a legislator would be voting for a committee report when he voted for the statute itself. And indeed, I suspect, without having gone through polls or anything like that, that's what legislators think of. Lastly, and I'm not going to take my full 20 minutes, anybody can complain. Lastly, we hear that there is the following complaint that one hears about giving committee reports authoritative steps. And that is, it's about those sneaky staffers, right? Those sneaky staffers will then sneak things in to committee reports, distorting the proper interpretation of the legislation, and fooling all of those dumb congressmen who have to vote on it, right? Well, I have to admit, because again, you'll have hundreds of legislators voting on it at a bill, and as opposed to 9 judges. Actually, I guess I don't know how many there are on the 11th Circuit now, but I gather unbanked there is really unbanked. They have like 21 or something like that. One of those circuits. I don't know. So it's not likely to happen there because they're actually voting on it. I suppose that could happen if you have your paradigm dumb legislator with a dumb staff, right? But I have two things I'd like to say about that. The first is, what's the alternative? I haven't seen a good alternative mechanism. But the second thing is, I can't guarantee that legislators are going to do their job conscientiously, right? I can't guarantee that they will have that Charlie Wilson, remember Charlie Wilson's work? That Charlie Wilson will have a smart staffer reading every committee report and either explain, sort of winding him up, like, when Strom Thurmond was 100, I assume his staff was sort of like, you know, Bob Dole said he had a health care plan when Strom Thurmond was there. Whatever Strom Thurmond did. He ate a banana, I ate a banana. You know, in a few years, nobody's going to even know what that's about either. I guess for you all, the equivalent of Strom Thurmond would be Robert Byrd. You know, at the end of his life, it was, what was my name? In any event, the most that I can do, the most that you can do in the legislative process is to give legislators the opportunity and the information to do their job in the most conscientious, logical way possible. And I can't think of any better way of doing that than to establish a general rule which says that committee reports are authoritative. Now, I would say two more things, and I will sit down. I promise you're tired of me already. The first, is that going to resolve all problems? No, it's not going to resolve all problems. There are going to be unresolved situations, and the way that I would interpret a statute, and therefore the right way in that situation, is to ask how a hypothetically neutral judge who was living at the time that the statute was passed, but was considering all of the facts at the time of the interpretation, would read that in light of contemporary legal material. That's a long way of thinking about doing the best you can. The second problem is, what if you have committee reports that are conflicting? Your guess is as good as mine. I mean, honest to God. But again, all I'm trying to do is give you the best, given the situation, to give the legislator the most information possible to do his job in the most logical way possible as he sees it. And that's why I think the committee reports are good for it.
Okay, so we agree.
Oh. Uh-oh. I'll change my mind.
Okay, so I was a little surprised. I wasn't quite sure what Professor Maltz was going to say. This is a forum together by the Federalist Society. So I'm not the conservative one here, right? So a lot of you know that. So you normally would expect to have the conservative point of view laid out on one side and then the liberal view on the other. And I guess if I had to choose, I'd be the latter, not the former. Professor Maltz has come out in favor of committee reports and intentionalism, and I generally agree, and I find his reasoning compelling. But I want to add a whole set of other, unless I misunderstood here.
I'm not a pure intentionalist. I would describe it as text.
Okay, well, you'll okay, so I'm going to start kind of broad, and then I'm going to focus it in on interpretive issues. Because my view of interpretation really is connected to my view of government and the best way to structure government to move forward. So we had an election last fall, and in President Obama's words, the Democrats took a shellacking. So what is the message from that lesson? There's a lot of messages you hear. I think from the Republican side, we have heard a lot of arguments about how the election was a rejection of expansionist government, healthcare, stimulus, and things like that. In President Obama's recent State of the Union, which was generally well received and not too strongly criticized from the right, at least not in my perception, we didn't hear from, I don't think we heard from President Obama what we heard from President Clinton back in the 90s after his first round of midterm elections, that he got his own shellacking when Newt Gingrich and the rest of the crowd, the Republican crowd, took over in Congress. At that time, in Bill Clinton's January 1996 State of the Union, he famously said the era of big government is over. Right? Remember that? We didn't hear President Obama say that in his State of the Union. They didn't say the era of big government is not only over, it's here and it's here to stay, but if you read between the lines
That is kind of what he said. He argued for a vigorous government involvement and, as he liked to put it, helping us win the future. That's how he put it. I want to put a little bit of context on that in a second, but I will stand before you today, and I will tell you that not only is it not true that the era of big government is over, but I think that the era of small government is definitively over, or at least I hope it is, or at least for the future of the country. I think it must be over. And you're asking how to connect with this topic, and I'm going to try to connect it up. I think that from conservatives for several decades, and I would put this back to U.S. Steelworkers versus Weber, a 1979 Supreme Court case, where the Supreme Court, I think it's fair to say, reinterpreted a major federal statute in a very expansive way. This is Title VII of the Civil Rights Act of 1964. That was a spark that I think prompted conservatives from that time to the present to focus on this issue of statutory interpretation or legal interpretation more broadly, and generally to favor a textual grant interpretation and eschew intentionalism. Professor Maltz says he's not a pure intentionalist, and I'll wait for him to expand on that, but he did want to give a place to committee report. Well, that is, I think, anathema to a lot of conservatives, principally Justice Scalia, who is certainly the most famous of the federal judges who are pushing a textualist interpretive mode, but he's not the only one. And I see this, I perceive this textualist idea that we've had coming from conservatives now for a few decades as part of a much larger constellation of small government philosophies and theories. Right? So I think it's a pretty consistent theme of conservatives generally, and the Federalist Society meetings, so you probably have heard this before, that we need small government, we need limited government, and I think a consistent strategy we hear from the right on how to achieve small government is by limiting government discretion and limiting government power. So the issue of the day, at least the legal issue of the day, centers on the federal health care law and the Commerce Clause power. And so we hear from the right that Commerce Clause power must be limited. It can't be unlimited, it must be limited. And although it's a very different area, it's essentially the same strategy that we see when we turn to legal interpretation. From the right, we currently hear and have been hearing for quite a while this notion that courts should limit themselves to the text of statutes. When interpreting statutes, they shouldn't delve into extra textual material, legislative intent, committee reports. Justice Scalia is a big enemy of citing the committee reports when interpreting statutes. And the basic idea here is that limiting the federal court to consulting text as opposed to extra textual data, such as committee reports or more statements from legislators, that will constrain the discretion of federal judges. It will keep them reined in. And in a roundabout way, that's a small government. Instead of having federal judges who can go beyond the text of a statute to expand on statutory mandates and initiatives, keep federal judges limited to just the text, and that will keep the ambit and reach of federal statutory laws limited to the subject. Now, I think this is a bad idea. I mean, my ideas on interpretation, as I said a minute ago, are related to my ideas on government. I think we're at a crucial crossroads in our history. And I want to just name 4 different policy areas. And all of these areas, I think we are failing. Our political system is failing. Number 1, education. We are in bad shape on education. And we've been talking about this for a long time, but we haven't been able to really fix it or come to grips with it. We are continuing to work on it, but we haven't made a lot of progress, frankly. Second, infrastructure. I'm thinking here about the bricks and mortar infrastructure. One of the advantages that our economy had in the previous century over other economies was a tremendously well built out infrastructure. And we still have that advantage, but we are losing it. Our infrastructure is crumbling. It is not keeping up with the expanding needs of our economy. Tax policy, huge failure on tax policy. Just to focus on one aspect of it, corporate tax policy. We have very high rates, but very low revenue in our corporate tax collection relative to the rates. Why do we have such low revenue collection on corporate tax at the federal level at least? Because we have all of these special exceptions and loopholes and tax credits and ways that corporate entities can manipulate financial transactions to avoid taxing. And so we have an arbitrary result where many large companies are paying a pretty high rate by international standards because they're unable to work themselves into these loopholes, but others are paying a very low rate, maybe as low as none or 5%, even though they have tremendous profits because they're able to wiggle their transactions and their business operations into these various exceptions. This is on the left and the right. I mean, this is agreed that this is a disaster. And then finally, I will say, yes, healthcare. We have failed on healthcare. We have an attempt that was passed last year in Congress, very controversial. Nobody, even those who support it, think it's possible. But it is an attempt, and we'll see if it's constitutional or not within, I think, the next 24 months. I raise these four areas because there are four areas that are holding our economic progress back. Okay, education, infrastructure, healthcare, tax policy, these are all damaging to our economic progress. Yet our political system is too decentralized, too fragmented, to be able to deal with them in optimal or even adequate ways. So this is why I think the era of small government needs to end. We need to put a period on that idea, and we need to get behind the idea of an energetic government that can deploy its resources and its power to address the areas that are really holding us back in terms of our economic expansion and progress. We need to have, in other words, government institutions that have the power and the discretion to deal with these important policy areas. So that's my overarching philosophy of government, and that drives my understanding of my philosophy of interpretation. Because again, the textualist, the pro-textualist, anti-intentionalist mode of interpretation that has been advocated by Justice Scalia and numerous other conservatives, this is a strategy of limiting discretion of federal judges, of inhabiting the discretion of federal judges. And I would argue that we need to entrust government decision makers, including judges, with discretion. We need to trust them to have to use that discretion in ways that, all things considered and over the run of cases, will be better than if we take the discretion away from them. Judge Posner, who is a pretty conservative guy, he has written a lot on statutory interpretation, and in some of his earlier writing, he analogized the interpretive enterprise to what happens in a military conflict. So we're all used to the idea that in the military there's a chain of command. There's a superior and a subordinate, and subordinates are supposed to follow the command of the superiors. And I think that's true and wise in the military context. Similarly, in legal interpretation, there is the idea that the federal judges should be the subordinate to the agents of Congress. They should enact or promulgate the policy that Congress commanded or intended. And I think that's generally right. But I do think that when Congress passes a statute, it acts in a particular moment in time, it sees certain problems, but it can't see how the statute will be applied as time goes on. You can't see what unexpected twists and turns that it might produce. And just as in the military context, we want to have the platoon commander operate within the parameters of the brigadier general's objectives. We want that platoon commander to have the discretion be able to adjust to changing circumstances on the battlefield and the ground. Several years ago, I had a student in my legislation course who was sort of a second career person. He had a military career. He had served in the Soviet-Kosovo conflict in the Army as a West Point graduate. And we got into discussions of these issues, and we had a very interesting interchange. He explained how the command structure and operation in the U.S. Army was very different than in armies of Russia and other East European countries that were involved. And what he described was that American commanders or platoon leaders on the ground did have some flexibility and discretion to adjust to unexpected circumstances, but that the Russians didn't. And if the command did not come down from on high, come hell or high water, they would, keep with whatever the pre-established plan of the day or the week was, and this just had the effect of gumming everything up. Because there was not the flexibility and the discretion to adapt, I should say, to changing circumstances on the ground. We need to free our federal courts to use that same kind of approach, that same kind of discretion. Congress is an institution that has certain features and institutional strengths that courts don't have. But one of the limitations of Congress, or at least the policy formation process in Congress, it can't really deal with particularized instances that are unforeseen or not particularly thought through in the legislative process. Federal courts can do that. Now, this is not to say that federal courts should have a license to completely disregard the command of Congress, but they should have license to use some discretion when the text is ambiguous, statutory text is ambiguous, to adjust in ways that maybe even the enacting Congress itself, at the time it enacted the statute, would not have anticipated or have necessarily even endorsed. So that's sort of my general idea of government, and it drives the idea that really we cannot hamstring, we cannot tie the hands of judges with actual. We need to trust them with discretion, and that means we need to trust them to choose between in situations where there's conflict between text and intent. Sometimes the text does one thing, the evidence of legislative intent suggests something different. And we need to free judges to be able to choose between those two conflicting data sets as is appropriate. I have a couple other comments on the utility of textualism, not really related to good governance, but just more prosaic points. One is that this is an issue that's been out there for well more than 100 years in the American judicial system. And it's never been resolved, and it's not going to be resolved today. Federal courts have been resorting to legislative intent at least since the 1880s, and probably well before that. They continue to do so today. We now have what some argue is the most conservative Supreme Court in our history. Some might say that it's the Lochner era that was sort of the early to mid-30s court that might have been a little more conservative. But still today, even with this very, very conservative Supreme Court, we find the court itself and the lower courts as well, which tend to be stacked with Republican appointees, to be willing to resort to legislative history, committee reports, legislative intent, and in some situations to follow intent over clear text. And I think the leading case for this proposition, 2000 case, FD versus Brown and Williamson, this is the case where, this is during the Clinton administration, the Food and Drug Administration was undertaking efforts to regulate nicotine cigarettes. And under the statutory language that Congress had chosen in delegating regulatory authority to the FDA, the statutory language was clear and it was very broad. Nicotine was considered a drug, would be considered a drug under the text of the statute, and the FDA would have power to regulate it, and that power would extend to actually a power to prohibit or ban nicotine. That was the text. Those are the words that Congress chose in delegating regulatory power to the FDA. In Brown and Williamson, however, I think wisely, the Supreme Court, in the 5-4 opinion, did not follow the text. It followed what the court rightly perceived to be the legislative intent, which is that Congress never intended or really even imagined that in creating statutory structures which would delegate to the Food and Drug Administration power to regulate pharmaceuticals, that it would also be granting the FDA power to regulate and even ban cigarettes. And the irony here is that the 5 justices in the majority were Justice O'Connor, Justice Rehnquist, Justice Scalia, Justice Thomas, and Justice Kennedy. All right? Scalia signed on to this opinion. This is an intense, trumping, clear text opinion. If this court is not going to banish reliance on evidence of legislative intent, then it will never happen. So we should just say, you know what? This is not going to happen. Let's instead deal with a world in which federal courts sometimes rely on text, other times rely on intent. They have the discretion to choose between the two. Even today's court is not willing to do it. It's not going to happen. Let's instead focus on improving the decision-making in the way that federal courts rely on text, rely on intent, and also the way they reason in justifying that. Okay, so I will. Thank you very much.
To save some time for the question and answer period, we're going to shorten this rebuttal to 5 minutes. That's okay? Yeah.
First, it's just a kind of side note, even though I only have 5 minutes. Weber was not a case where the court limited the scope of Title VII. Weber was actually expanded the scope of Title VII. Weber was a case where they limited the scope of Title VII. That even though the language says no discrimination on the basis of race, they decided that I think little pieces from this piece of legislative history and that piece of legislative history, the court decided that it did not apply to what was described as, or might be described as affirmative action, race-conscious preferences, and fill in the blank. It's hard to find a non. Now, I think that the way Congress was thinking about it, I think they wrote a bad statute, and I think Weber is wrong for that reason in that sense. But I would also, on a broader, if I was going to take the broader case where they broadened Title VII by picking this little bit of this, a little bit of that, a little bit of other things, I would say Spriggs versus Duke Power, which was a disparate impact theory into the statute, clearly wrong as a matter of what I would describe as text and context and any reasonable reading of the legislative history. That having been said, leaving Title VII aside, I'm not an intentionalist. No. I'm not a crook. No. I'm not an intentionalist. I would describe myself as a variety of textualists, and the difference being that I don't think I'm not saying you can look at all parts of the legislative history to find whatever you want. You can find anything you want in the legislative history, right? Look at how people on the left are interpreting the 13th Amendment now. It's like, oh, the 13th Amendment requires minimum wage laws. You can find whatever you want in the legislative history. Even a textualist has to look outside the statute to find the plain meaning sometimes, right? The question is, the problem is, with sort of traditional textualism, is they're looking at dictionaries. You look at dictionaries can be different also, right? My idea is to have one source which will tell us what if Congress can, if there is such a source, if Congress decides to provide such a source, you look for one source, the courts look for one source, and that is more constraining rather than quote plain meaning. Because again, there is no such thing as plain meaning. You know, the president has to be 35 years of age, right? 35 Venusian years? 35, no, seriously, that you have to look. And so I would describe myself as a species of textualist. You know, maybe a mutated textualist, I don't know. Watch out, I have 4 horns now. But so that's how I would describe what I would do. And what I'm actually looking for is more constraint rather than less constraint. And the question is, way back when I was young, there was a show that Johnny Carson, of all people, was on called Who Do You Trust? I'm not as big a fan of, I trust neither legislators nor courts, but I'm a formalist. And I think that legislators ought to be able to do the job that's assigned to them, both state and federal legislators, by the Constitution, the state and federal Constitution. And that includes being able to predict how the statutes are going to be interpreted, and also to provide materials that will help ensure that they will be interpreted that way and have judges respect that decision.
Well, I don't have a whole lot of comment rebuttal. I guess I understand your position better now. I do understand that you're constrained from focusing on the committee report as the leading or maybe the whole basis of going beyond. I see that point. And this is where we disagree. I think that, and you probably won't be able to come to reconciliation today, but again, I favor delegation of discretion to the players in the system who are actually on the ground applying statutes. And that means judges. It also means that really, this is really for remote statutes. If interpretation occurs at the federal level, that means the agency who applies federal statutes. Congress is a body that, again, has certain capacities and strengths, but what it can't do is see all of the variety of ways in which the statute that's passed will apply on the ground, and we need to push down discretion to those who are on the ground, who are applying it in individual situations, not to contravene the command of the legislative body, but to fill in the gaps, to do what the legislature probably would have done if they can determine that. Had the legislative body, the Congress, thought about the novel issues that come up, and really sort of, the fear here is whenever you push discretion into low-level, on-the-ground decision makers, they will abuse the discretion. They will screw it up. And I think that is true. They will screw it up. Whenever you give someone or an entity discretion, that discretion will, in some percentage of situations, be abused, not intentionally be abused, at least mismanaged. The question, however, is which is the greater evil? Is the greater evil taking away all the discretion from the low-level, on-the-ground decision makers? Do you want a platoon commander to stand guard and cannot proceed towards the objective today because some unforeseen circumstances come up and the road is blocked, and we're not permitted by our high-level command to take a side route around this blockage? Do we want that? Wouldn't that actually produce more problems when you take the discretion away than the problems you get in mistaken application of discretion and or abused discretion? Now, as far as abused discretion, as I said, I don't think that it's really realistic. I think that the federal courts will ever give up the tool of resorting to quote-unquote a legislative intent. They're just not going to give it up. It gives them the flexibility when they want to follow the text. If the text is not in line with the evidence of legislative intent, a court can choose an intent. They're not going to give that discretion up. What we ought to instead focus on is developing ways to minimize the error rate in the use of judicial discretion. Minimize the opportunities for abusing the discretion and minimizing the opportunity for the situations where courts will mismanage or botch the discretion. So I think our fundamental disagreement is on the discretion issue. And you want to limit discretion by focusing courts just on the committee report. But I think if you do that, you will limit the discretion in a lot of cases. And that's what we're doing. Open it up for questions.
Ron will moderate the questions and answers. Please be brief and respectful in your questions. Please state your name and class year.
Brian as well. You bring up the issue of who you trust. I mean, my initial reaction to any government power program is first not how will this work, but how will it be viewed? And maybe that's just the attitude you get at the Federalist Society meeting. But the first thing that pops into my head when we talk about allocating discretion to judges or to lower level people is exactly when it's viewed. When you think of things like sentencing guidelines, every judge thinks they're fair, and before it was always mandatory matrices of sentencing, there's the history of minorities or other people getting harsher sentences for the same crime goes way back. So it seems to me that you can find chock-a-block cases of that abuse of discretion. So the question sort of devolves into an empirical one, right? I mean, you said, is it going to be abused or is it not going to be abused? I guess my question to both is, I mean, is there an answer? Has there any kind of empirical work been done? We go out into the field and say, okay, well, 80% of the time it gets abused, 10% they get it perfect, and 10% of the time you don't quite know.
First, going to that.
Well, I don't think that I've seen any of that empirical work. I don't think that you can make general rules that are generally applicable across all circumstances. You need to look at individual circumstances and adjust discretion, possibly you give the adjustment to what is actually working. But my argument is that this notion that we need to strictly limit court to statutory text, to the ordinary common meaning of the word, you end up with more. Usually what happens is when a court, especially these days, when a federal court says, we're not going to follow the text, we're going to follow the evidence of legislative intent, it's usually a narrowing construction. Usually the text is unintentionally and unfortunately too broad. It covers too many things that Congress really didn't need to capture. And by resorting to a committee report or other conditional legislation, usually the result is for the court to, say, well, actually the statute doesn't apply to D, E, and F. It only applies to A, B, and C. So, I mean, you just need to have a goal in mind, and that's to figure out where is discretion best placed in different situations. Sentencing is a good example. There was too much discretion. But then going to an absolute ironclad, no discretion regime was also a mistake. You need to have ranges within which judges could. And then, of course, you still want to combat the problem of disparate impact in application of those ranges. Well, you need to do studies and show what the results are. If the results are problematic, you need to adjust on the fly. But just to have this as a one-size-fits-all, we're so afraid, we're so paralyzed that discretion might be misused, abused, that we're going to take it all away, is throwing the baby out with the bathwater. I don't think right now.
I'm not against discretion per se, but I think my argument is more formal than it is pragmatic, in that I think that if Congress thinks that it's a good idea to provide discretion for federal judges or for agencies, I mean, they set up these agencies, particularly in lots of cases, and provided them with discretion. The question is who decides how much discretion. Part of it is who decides how much discretion there's going to be. And my view is, again, it probably has to do with my toilet train or something. I'm sort of a rule-based formalist. And that it seems to me that Congress ought to be able to make decisions to deny discretion if it wants to. And one of the problems with wide-ranging looking, I agree with you, judges aren't going to give this up, I'm just going to make it harder for them, and at the margins it might change their behavior. One of the problems is, again, I go back to Title VII because it's a classic example. In 1964, Griggs versus Dukauer was a decision which established the disparate impact rule, which basically was anyone who knows anything, and I'm old enough to actually sort of remember what happened. I'm older than everyone. But I can sort of remember what the summer was like in 1961, things like that. And, if you took the legislative history as a whole, really, or knew anything about what was going on, they said, nothing like that could possibly have happened. And that they said when it was talked about in Congress, it was said, oh no, we're not doing that. But by taking this little piece here and this little piece there and this little piece there, by allowing this wide-ranging look at everything that anybody says in legislative history, you can find proof for anything in legislative history, right? You can find proof that Sarah Palin is actually Albert Einstein. I'm sorry, some Sarah Palin fans out there? Okay, all right. or Charlie Ranglin's Action Republic. The point is, I want to focus I want to allow Congress to do their job as well as they can. And by having an authoritative source, rather than looking at all sorts of different dictionaries, that's what I'm looking for them, to have them do their job. If they want to provide discretion, they should provide discretion. Now, and if they don't want to provide discretion, they should say no discretion. The court should say no. And in between that, this is my problem with Weber, even though they didn't think about it. Actually, that's a whole different story. I do think that unless you can find some pretty darn good reason to say that plain meaning is not what plain meaning is, right? That plain meaning on a government, but plain meaning in, when I talk about plain meaning, I am not talking about dictionary meaning. I am talking about the idea that statutory language is or it should be interpreted as legal terms of art, because Congress thinks of themselves as creating legal rules in the context of existing legal rules. So that's where I am, and therefore that's right.
Frank Rollins, Nick, regarding the small government, big government dichotomy, well, first I'd argue that I'm wrong. That the era of small government, I guess you could argue, has been over since 1937. But if you were to make an argument for delegation of authority to bureaucracy, which is essentially what we're talking about here, then we're throwing any idea of enumerated powers out the wayside. The FDA case example seems to me to be something that the conservative justices, they chose that argument because otherwise they would have to open up a Pandora's box and say that Congress can't establish regulatory authority to ban nicotine. I mean, that would be a whole different ballgame. And my question is, do you think that solving, or also one thing that the issues that you consider necessary for government involvement is easily argued for government, for less government involvement, easily. Right. I would say stronger than that. But do you think that America should go toward a expertise European model, and that the path to that is taking various non-textual approaches to legal issues?
Wow, there's a lot of discussion. Okay, well, I just even though the topic, I'm just going to address the big government, small government, just really quickly. I mean, I believe free market, but I simply think it is factually wrong to think that free market, at least optimally functioning free markets, emerge organically and on their own without government. So government is a necessary ingredient to creating the structures in which free markets can operate optimally. So again, infrastructure lowers the cost of all markets, transportation and things like that. Education, you can't have a good free market if your entire population is poorly educated. You're just not going to be competitive on the world stage. Healthcare, this is the one you probably most experienced now, but I think that a society needs to come up with a way, and to fight about which way it is, to ensure that people are not people can have access to healthcare. How many people are out there working in cubicles in our corporate enterprises thinking, if it weren't for the healthcare, I'd go start a business, right? If you don't have these basic things that only government can do, it screws up your market. But that is
believe that we have to have an activist government, but it has to be aimed at the right things if we really want to be competitive on the state. Now, as far as FAA versus Brown and Williamson, I don't think that the conservative side in that case adopting the intentionalist interpretation over the clear text was an attempt to avoid what would otherwise be a constitutional problem. I mean, it's clearly within Congress's power to legislate and regulate pharmaceuticals or physiology altering substances. Now, you might not disagree with that, but I think that the current Congress supports that notion. But generally speaking, I think that now getting to your discretion issue, you don't want to adopt a European model. I don't know. That's pejorative in a European model, but I will say this: generally speaking, my own personal default position, whether you're talking about public institutions or private corporations, is that the organization will generally work better to the extent that you can push decision-making power down to the people who know how the policies are really going to work in practice. So if you have a corporation that is too rigid and too where the management directives come on down from high, when the management is kind of too disassociated with how that's actually going to work in the organization, that's going to be a problem in the private sector and as well as in the public sector. So you need to trust your lower level decision makers with discretion. They will make mistakes. They will. I mean, you talk about Weber and Griggs. They will sometimes abuse the discretion, but that is a necessary cost of pushing discretion down to the lower level decision makers. I think it's all things considered, that cost is much less than the cost of tying the hands with decision makers who are actually they are close to the situation, seeing how it will respond.
I like a lot of things that were said about discretion. I think a lot of good can come from granting discretion, but I think that one has to separate one's political and pragmatic views from one's jurisprudential views. And so what I'd like to hear is why, how can we square granting judges the discretion to ignore and change the text of legislatively enacted statutes with the principles of separation of power in the government. And I mean, we've all heard of the anti-utilitarian concerns. Judges are, appointed like premiums, during the pay, and so on. So they're not accountable to the people. But we can't just mesh what we think is politically expedient without having a good theory to explain why that's the case.
One thing about this is just push on a point. When we talk about federal courts, we see anatomy problems as big as statutory and constitutional concerns. People talk about the quote counter-majoritarian difficulty. I assume that's what you were referring to. First, it's not so much counter-majority. You have two things going on here. First, you have courts and legislatures. Then you have federal and state. Most of the things we're talking about don't have, even though it's been fashionable to talk about counter-majoritarian difficulty for a very long time. The real problem is when federal courts do reach out to things that they are not supposed to, not enclosed, is that they constrain what happens at the state level. And that's not about majoritarianism, that's about federalism, which is really the biggest issue to me in judicial review of state legislation, or in expansive judicial interpretation, expanding judicial reaches, federal statutes, because that constrains state law. So do you think that's a good idea or not to say? I agree with you, we have to distinguish between our structural argument and our political argument, even though they're related. Moreover, even with respect, Congress was never newsflash, notwithstanding what the War Report said,
that Congress was never designed to be military in that sense, that there are decision-making structures built in. And again, in fact, I'm a formalist, that's where I am about it. It's a sort of philosophical, sort of prudential position rather than a position. I'm not one of those that, the Constitution's really clear, but that's the way, that's the way it was set up. And the problem is not that it's counter-majoritarian, but rather that it's the counter-legislation area or whatever. And I would just distinguish between those things.
Okay, so but what I hear you asking is how do you square this judicial discretion with legitimacy? Right. There's some theory of legitimacy, and I think that maybe I'll just build a little bit about authoritarian problems. Congress is a democratically elected institution. It is also incredibly dysfunctional and incredibly unpopular. Despite that, the reason that it is unpopular is because its work product is terrible. So it can be as democratic as all get out, and people still won't be happy with it if the product is bad. And I would say that same principle applies to this issue of dividing discretion between Congress and agencies and courts who actually apply statutes. I suppose to the extent that you delegate decision-making discretion and authority to lower-level decision-makers who are not democratically elected in agencies and in the federal courts, you do lose something in the democratic legitimacy scale or end of it. But if you get a better result, I guarantee Americans are generally happy. They're not going to lose sleep unless they're on the side of them. I don't think they're going to lose a whole lot of sleep over the fact that the good results or good decisions are made by agencies, bureaucracies, or federal courts.
I want to take 2 more seconds about the counter-majoritarian thing. That if you want to look at perhaps the case which ranks in the top 10, if you think about counter-majoritarian difficulties, the top 10 of deliberately ignoring the text and doing what you feel like, I would nominate Westbury versus Sanders, which is a case which is generally not studied in constitutional law, which established the principle of one man, one person, one vote for elections to the House of Representatives that is directly contrary to the text. Directly contrary. It's not most constitutional law, but so this idea that the Constitution establishes a democratic government is a myth. That's just sort of our founding myth.
I don't know if
One more question.
Mine was just a question about mentioned that one involved in research. I won't get into that, we're already at where does that come up from? How do we know that this infrastructure is one of the big problems? Whether the goal to solve the thing on its own? It's always an accident. Infrastructure.
Well, just one thing about local airports. The 3 local airports are I think the top 4 in delays, and that's always a drag on the economy. This is a little itty bitty example, and they're just pulling out last week's newspaper proposals to expand the airport. This will take our current government structure way too long. I guess there's going to be the market will provide the airport.
Could it be that the airfare price was way too low in the right place? Maybe that's what.
Yeah, but the problem is that market often the work is in technical, so the factors of production are going to congregate in Manhattan and buy a house. The human labor factors are going to buy a house, which they have yet. Move to Kansas City with an airport, and they're going to work for a company that wants them here. And it's just that look, throughout our history, throughout our history, the government has played a crucial role in lowering the cost for the entire economy by building out infrastructure. Now, if you go back to the early history of this debate about canals, the argument was the federal government did not have the constitutional authority to build canals. That was, I mean, a state issue. Railroading in the Civil War, Civil War era. This is my belief structure. I could be wrong. I'm not, but it is my belief structure. And this is what drives my idea about energetic government. And if you're going to have energetic government, you need to push discretion down decision making. Otherwise, it's just not enough.
I'm actually going to support Professor González, and unlike him, I'm never wrong. But I will give a better example. I think a better example in the airport. Interstate highway system, you could never build that.
Right.
You could never, which is now falling apart. You have an interstate highway. But here's the problem in terms of your belief structure with respect to discretion. If you look to the what I consider thinking of the three biggest infrastructure things that were done, one of them is before my life. Right? Not out of the case. But I'm thinking of the Manhattan Project. I'm thinking of the Apollo Project, and I'm thinking of I'm thinking of the interstate highway system. And none of those were built. All of those were built, strangely enough, and I'm not. I'm a Soviet-style communist. I'm old. I'm not that. But my point is, all of those were built on one side. They're built by central command building, but on the other hand, I think that further that with respect to not the interstate highway, even with respect to the interstate highway system, but certainly with respect to the Manhattan Project and the Apollo Project, they were successful because of this kind of decentralized decision making you were talking about. You got a command from on high, and they just said, in the immortal words of that great Democrat Maltz, they let 1,000 flowers bloom. They just threw money at every at sort of local level, small level, try to get to every conceivable situation, and let the one that worked the best ultimately rise to the top. Now, I'm not sure exactly how that cuts in terms. It cuts in favor of active government. I'm not sure how it cuts in terms of command versus discretion. I'm sorry.
If I could just comment on a couple of things. So one, if you look at the example of air travel, so the part that is most controlled by the federal government is the air control system. It's a single system across the entire country, and it currently uses 1950s, 1970s technology. The
Worse
federal
technology
government,
than in your eyes.
way worse. For years, the federal government has tacked on surcharge to airline tickets in order to create a trust fund in order to replace the system. And Congress continually refused to spend the money in order to upgrade the system because keeping that money on the books made the deficit smaller. And so you have a situation where because the incentives are all screwed up and because it's controlled by a monopoly at the federal level, you have no opportunity to improve that system. And so you end up with planes that don't fly direct routes, they end up spending more in fuel. Air flights take longer. And there have been multiple proposals in order to fix that system, but they never get through because there's no competition. There's only one political.
I agree with everything except one key part. I mean, I would say the problem is that decision-making power is not pushed down. Congress has too much control. The way that this policy should be addressed is Congress should set the broad outline and then give a bureaucracy that doesn't have to worry about the overall budget or other, to just go do the job and get it done. The problem is that we're letting Congress micromanage too much, and when they do that, they're screwed up more than if they would push the discretion. If they would just say, here's the money, here's the broad outline, go do it. Limit it.
It's just because, so I think that's the best argument for limited government, because you want to push the discretion down and you want to have the people who are opposed to the end result dealing with it. Well, that's not telling me how I should build my house based on some bureaucrat in Washington, but that's letting me deal with my local set of elected officials who can decide how we want to do it ourselves. Great.
very much, Professor Maltz and Professor González, and thank you to everyone for attending. Our next event will be next week on Thursday, at the same time, 12:35. We'll be co-sponsoring a debate on the lasting effects of Roe versus Wade with the law students for reproductive justice. We'll be bringing in Dorinda Bordley from the Center for Bioethics, and she will be debating Professor Caitlin Boardman from the School of Law. Thank you very much.